Mediation is an informal and confidential way for people to resolve disputes with the help of a licensed mediator who's also a neutral third party. And it is one of the most important aspects of all divorce cases. First of all, mediation is required. In virtually every family law case, a mediation session must take place within 6 months of the final hearing. The mediation process itself is relatively simple. Typically, you and I will sit in one conference room. The opposing party and their lawyer will sit in a separate conference room. Mediation is confidential. Third parties are not permitted to attend. And those protections are put in place for the purposes of helping parties be flexible and exploring new ways of potentially resolving conflicts. The mediator will look to the petitioner first for an offer of settlement, and the mediator will take that offer to the other side and get their feedback on what is acceptable or what changes they would like to see made. This process then continues back and forth, the two sides negotiating, until we are able to either reach an agreement or we reach an impasse. Typically, mediation will last for several hours, and it can be a trying process. But by working through the issues one at a time and being conscious of the mediation parameters we developed in advance, we are typically successful at mediating agreements for our clients. I cannot tell you how many people have come into my office over the years complaining about a settlement they reached, even while they were represented by counsel, and asking if the agreement can be changed or completely set aside and vacated. The answer is usually no. With very few exceptions, once you sign a settlement agreement, it is basically an enforceable contract. So in order to prevent bad agreements and to make sure we get things right the first time, we focus on making sure we have properly prepared our client for mediation. Before every mediation, we meet with our client, we review the issues that need to be resolved, and then we develop two positions for our client. The first one is our most probable outcome in court position. This position involves assessing our case and anticipating what a divorce judge might do with the facts of the case. The second position is the minimum that our client is willing to accept in order to bring the case to an end without further litigation. We use these positions as our negotiation guidelines at mediation. Effectively, there are guidelines on what constitutes an acceptable offer and what does not. By developing the mediation parameters in advance, we prevent our client from getting caught up in the moment and agreeing to something that they would not normally have said okay to. Our mediation parameters give us a warning system that tells us when to pay careful attention because our client is considering an offer that is outside the range of what we consider to be acceptable. Mediation is also vitally important because agreements are much more likely to be complied with by the parties than an order that is imposed upon them by the ruling of a court. Important to remember, the mediator has no decision-making powers. He is not the judge. His only role is to try to help the two parties reach an agreement that best suits their needs. Mediation agreements can also be more flexible than that of a court order. In mediation, we can be as creative as we need to be to draft an agreement that works best for you in the real world and that meets the unique needs of your family. And then, of course, you should also be aware that settling a case at mediation is much less expensive than going to trial. And for that reason alone, we at the law firm for family law put an emphasis on trying to settle your case as soon as possible rather than dragging it through the entire litigation process. As a Florida Supreme Court certified family law mediator and as a certified divorce financial analyst, I'm proud of the help we can provide our clients in using mediation as a method to resolve conflicts involved in their case without the need for a trial. Call our office today to talk to us about how mediation can help you resolve your dispute.